The Beach FM Business Lunch Show, brought to you by PlaceMakers Kapiti Horowhenua. Together we're building New Zealand.
Welcome back to the Business Lunch Show on Beach FM 106.3. Let's welcome back to the show to talk employment law from Wakefields Lawyers. It's Amy Webster. G'day, Amy.
Hey, Damian. How are you?
I'm very good, very good. Hey, we had a late start to last month, but we've got our first Monday locked in. And my friend, how has so much changed in such a short time? There's a new leader of opposition. There's a new workplace relations minister. There's new amendments to bills. Where do we start?
I know. It's been a lot of change. I suppose a couple of things happened late last month, which are worth talking about from an employment law perspective. Yeah. The first thing is that the Equal Pay Amendment Bill passed, which is a pretty big deal. So we already have an Equal Pay Act. Everyone will be thinking, don't we already have law around this? And we do. But that law is very much focused on men and women doing the same job being paid the same. So that's sort of quite straightforward. But a few years back, there was a case that I'm sure everyone remembers where essentially a court said it's not just about the same job, it's about professions that have been traditionally, I suppose, undervalued because they're female dominated. So what this law does is sets up some guidelines around how female-dominated professions can go about bargaining for equal pay.
So something I saw was it's more skills versus experience kind of deal? No?
Yeah, so essentially what happens is that if an employee feels that she is sort of being underpaid as compared to sort of a comparable profession, what this law does is sets up a way to go about that. So essentially, you would, and the kinds of professions that we're talking about, I suppose, are nurses, teachers, retail, care workers in sort of the elderly care area, that sort of thing. And what this will lead to, I suppose, is industry-wide negotiation. So things, the framework of sort of collective bargaining will come into it. But essentially what the Act says is that you're looking at a profession where the workforce is approximately 60% women, so that's not hard and fast, but you're looking for a profession that has traditionally had a lot of women in it. It doesn't need to necessarily be female dominated now, but if it has been for a long time, then that also comes under there. And essentially, it's where, as I said, an employee believes their occupation's been undervalued, and therefore they're not being paid as much based on the fact that they're a woman. So what happens is that an employee or a group of employees would raise an equal pay dispute with their employer, and if the employer agrees, then great, you negotiate and you sort it out. If the employer disagrees, then essentially what they need to do is compare the work that the person's doing to a male-dominated counterpart occupation. And of course, there'll be some negotiation around what the counterpart is, but it's got to have sort of the same or substantially similar skills, responsibility, and service. So I think an example that was brought up in that case a few years ago is that these aged care workers were paid less than the gardener or the janitor, which was like a male-dominated occupation where it's required less skills, less responsibility, that sort of stuff. And so that's how they sort of were able to draw a comparison.
Wow. Okay. So how does it come down to measuring all that? I mean, is there going to be new training done for employers, HR departments to tick the right boxes? I
imagine the government has a pretty good website, the employment.govt.nz site, which has a lot of information there for employers. So I imagine that a section on this will pop up pretty quickly. And I would have thought that the first sort of few rounds of this will probably be taken up by unions, and they will sort of fall back on their traditional sort of collective bargaining way of doing things, and that will help kind of lead the way in terms of how this sort of stuff's going to happen. And once a few examples start coming out through the authorities and the courts, that will help others to kind of get their heads around how to deal with it. But yeah, and obviously the Act sets out some of what people need to know. Yeah.
Excellent. Okay, and the second change this week, in the last few, was change to bereavement leave.
Yeah, so the change hasn't actually come through yet, but it's the second reading of the bereavement leave for miscarriages amendment bill happened, and this is a private member's bill which has come through, which is essentially intending to give parents who have lost a child through miscarriage or stillbirth essentially a right to 3 days of bereavement leave, or up to 3 days. So when the first reading came through, the first version of the bill, it talked about the unplanned end of a confirmed pregnancy, and there was a lot of discussion around how on earth you work that out. So the second reading of the bill is a lot more straightforward. It just talks about the end of an employee's pregnancy by way of miscarriage or stillbirth, or the end of another person's pregnancy by miscarriage or stillbirth, and then it kind of sets out a number of relationships. And this was another criticism of the first version of the bill, that it just talked about the person's spouse or partner. And a lot of people said, well, hang on a minute, what about former partners who are biological parents? What about foster parents? What about XYZ? So there's a list in there now that talks about spouse or partner, former spouse or partner who would have been a biological parent, people who were ready to be the primary carer, so that's people who are going to adopt this child, and the definition of miscarriage and stillbirth has been amended to clarify that this bill doesn't cover instances of abortion. And as I say, it's a second reading, and it's now at the committee of the whole House stage, and you've still got to get through a third reading for it to become law. We're now in the last sitting week of Parliament before the election, so I don't know that this will be a high enough priority to get through, because I think there's a number of sort of urgent things that they're trying to push through. But on the whole, this has pretty good cross-party support, so I would have thought that whatever the government looks like on the other side, it will get picked up. So I suppose it's just something for employers to be aware of. If and when it comes through and it becomes law, just being aware of it, and being aware of possibly needing to update employment agreements, having an understanding of how to deal with this sort of thing. So before somebody comes to you and says that they've suffered a miscarriage, understanding what you need to know in terms of, I suppose, proof or evidence, or have the plan in place beforehand, so that when you've got a distressed person in front of you, you're not kind of asking them for proof when it's inappropriate, or that sort of thing. But yeah, I mean, I would have thought that this is going to become law, so it's just something employers need to be aware of. It's not law yet, but that doesn't mean an employer couldn't interpret the current law to cover this if they so wanted to. And there are people who argue that the current law does cover this, and then there are people who argue that don't. So this is this is a clarification of the law. So there's nothing to stop an employer now granting bereavement leave in this sort of a situation.
It'd be a touchy subject if it was expected to just come back to work the next day, I would imagine. Yeah,
exactly. It's a kind of a long overdue kind of clarification of the law, in my view. It's a very, very difficult thing for people to go through, and often it's something that people don't talk about. So having a law there that says in black and white, you're entitled to leave for this reason, will hopefully make people feel comfortable to talk about it and ask for this leave, because grieving in that sort of a situation is very important. Yeah,
absolutely. Well, Amy, anything else that we should know or we should keep up to date with?
I'm sure there will be, not off the top of my head, but I will endeavour to keep people updated as these bits and pieces of the law change. Excellent.
Well, last, as always, where can we get in touch? How can people find you?
they can go to our website, wakefieldslaw.com. We're also on Facebook and LinkedIn. And I believe that we're on Instagram, but I just don't personally have an account. I'm not cool enough for Instagram, but I believe that people can find us there too.
Well, I always appreciate your time, mate. Go well, and we'll catch up next month.
Sounds great. Thanks, Damian.